Yes, welcome to the No State Project live from the fortified compound in Mesa, Arizona. Glad to be with everybody. And everyone start filing in. But it is November 9th, 2019 edition of the No State Project live, of course, from the fortified compound. And I get to do the show an hour later today because Arizona doesn't change time. So I love this time of the year because it's easier for me to do the show and because it's an hour later. And the weather is just outstanding. It's been, it it's a look. It's a bad time because of the death in the family and whatnot, and still making adjustments. But some things stand out. We've had a decent week. No tech issues. So yeah, I'm gonna go ahead and maybe go and jinx it so that maybe so far. We're starting the third show in a row without a tech issue. So everything seems to be going pretty good. But hey, we never know here on the big show. So we'll see what happens there. But if you want to join the show, 218-632-9399, 218-632-9399. The passcode is 2020 with the pound sign. That will get you into the queue. Also, if you want to reach me on Skype, I guess I got to move that. If you want to reach me on Skype, you can do so by instant messaging me first at Frank Rizzo 3. And no passcode for that, but instant message me, and then we'll get you on the big show. This way I can mute things out and bring you up and sound sort of professional here on the big show. Well, if we don't have the tech issues, we can sound pretty professional. So, wow. If you want to help support the show, apparently it's really needed. And I do appreciate everyone's continued support of the show. If you'd like to help, it is you can do so at markstevens.sales.com. That's sales, S-E-L-Z, markstevens.sales.com, and also at markstevens.net. Remember, markstevens.net, you can also get the scripts and the templates, instructions on filing them in court. And you also can get Government Indicted, which as a full model of how to effectively defend yourself in court against these code violations. And so you can, if you want to see proof, and damn it, you should want to see proof. We've got plenty of that on the website, markstevens.net, under these success stories where I am behind in a major way on success stories. Of course, we'll throw in the train wrecks when we had Lucas in Philadelphia, Mississippi, and so I'll include that. Don't want to give anyone the impression, any false impressions at all, especially here where you think that, if I buy the motion, I'll win. Not necessarily. No, there's a lot of factors at play there, a lot of variables that you have to keep in mind when you go into court. And I haven't said this in a while, but we bring in an anarchist mindset when we're going into court. We're not accepting. It's also as a skeptic that we're not accepting what these predators are saying is true. And I tell you, if you accept what they're saying is true, it's going to be to your peril. If they want to convict you, they want to get their money out of your pocket. And I think it's just a very wise thing and a much more effective way to frame a defense if you're not accepting any sacred cows. And what I mean by anarchy is that no ruling class, no rulers. Doesn't mean no rules. Just means no ruling class. Because what we have now is a ruling class. And they're propped up by violence. We believe as an anarchist, or at least I do, that it is wrong to lie, steal, kill, and cheat people just because you call yourself a government. That we are going into court knowing that if you force people to give you money, you are a criminal. You may actually do good things with that money. You may build roads and stuff like that. Yeah, but you're still a criminal. I mean, it reminds me of when supporters of John Gotti. Really? This supporters of John Gotti? Yeah. And, he kept Howard Beach. He kept his neighborhood safe. Like, at the expense of other people's safety, at the expense of other neighborhoods. Yeah, he did good things. He kept his neighborhood safe. He had a whole thing every year on the 4th of July. Money he was stealing from strangers and killing people in the process. So it doesn't matter if you're doing perceived good things with the money that you're stealing. So yeah, there's a whole infrastructure. There's all these services that are valuable and people want, but they should be provided on a voluntary basis. I mean, that there's no force continuum behind it. And so when we go into court with that mindset that the slate is wiped clean, we're going to let the facts speak for themselves. We're going to do our best not to impose our worldview or preconceived notions on that. And when you do that, it's a hell of a lot more effective because you're forcing the other side to actually prove that their claims are true. And they don't like to do this, which is why they are so desperate to help the police officers out when you start asking questions regarding the facts supporting their legal claims. All right, somebody is saying here, J.C. Warren, hi, Mark. My husband just got 2 tickets in Fishkill, New York, on our way to Florida. So Fishkill wasn't bad enough. That's not a bad enough. You're going to actually go to Florida. Okay. I guess going to Florida now is better than going in July. No seatbelt and expired license. We'll be ordering templates soon. Okay, well, we do know in New York, for example, that it's a 2 years that they have for the so-called speedy trial. You imagine a speedy trial take 2 years? That's speedy? What the hell is one where they're just sitting on their hands? How long is that? Tickets do not state what the penalties are for the offenses, but state that a guilty plea is the same as a trial conviction. It seems like this is a criminal infraction, which, wow. I am so glad that I don't live in New York anymore. I was just watching a Jim Brewer thing this morning where he was saying at a certain point after living on Long Island where you just car slides in the sleet and the slush. That's where I'm done. I'm moving to Florida. Of course, I moved to Arizona. I don't know. That would be my first pick. Anyway, it looks like you got a criminal infraction. New York State Police had a checkpoint set up at an exit. Yeah, well, there you go. You try to get away. I hated so much about New York. Yeah, people can talk about the food and some of the food. Yes. Yes. Brooklyn and Long Island has some of the best pizza and cannolis that you can imagine. But I would never move back to Long Island. I don't mean any disrespect to anybody, but not a chance in hell, even just for the humidity. I guess I could go back to visit, but to live there, I tell you, I got no love lost there. I am so glad to live in Mesa and live out here in the valley. Yeah, I think it's going to be 84 degrees today, bright and sunny. So, I'm not. Anyway, that's got nothing to do with what J.C. Warren is asking. The motion to dismiss, for those who are not aware, is based on a lack of evidence proving jurisdiction, and that is personal and subject matter. So that's important to keep in mind there. 2 aspects of jurisdiction. So, and they're based on the same thing. This cop, if he was to go to testify, would testify that he saw you in New York, physically in New York, and in his mind, I won't make an insult here, but in his mind, physical location equals jurisdiction, that the laws apply and he's got jurisdiction to investigate. It will completely fall apart when you start to question. But we'll talk more about that. I also want to talk about these bad arguments in court. Please, if I never get another phone call with somebody, to the show claiming a straw man or the name in all caps, boy, that'll be a good day. I'll talk more about that in depth after some calls. Let's get to this. We've got Atik. I hope I said that right. In Sacramento. Welcome back to the show.
Hi.
Hi.
Hello, can you hear me?
I can hear you.
Hello?
Yeah, you're live on the show. You got to do better than that. Now, for some reason, he's not
Hello?
here. Yeah, you're live on the show. For some reason, you're not getting my audio. I think maybe I spoke a little too soon. All right, we're going to see if it is Atik.
Hello?
We're going to mute him back up there. We're going to go to... Now we've got Mac in BC. Mac.
Hey, Mark.
Hey, how's it going? You can hear me, right?
I can't hear you on the phone.
Oh,
I
what
got
the hell?
I got the YouTube playing in the background. I hear you there, but I can't hear you on the phone.
Oh man. Well, that kind of sucks.
Looks like tech issues.
Yeah, it looks like we've got a tech issue. Son of a, I can't. Let me make one minor change. Maybe this will do it. Okay, you got me now?
Yeah, I can hear you.
I swear to you, I don't know where. Okay. All right.
Can you hear me?
I can hear you. We've been able to hear you perfect, so you weren't the problem. I was the problem. So, of course, Stahl, you were right. I jinxed it.
What is it? Do you just got to mess with the settings each time, or you forget a setting, or what happens?
I didn't touch anything from the last show on Wednesday. I should not have had to do that. It's not the way I've got it set up. I shouldn't, but at least it's just on my microphone, and it wasn't, because if it was the other thing, the other part of the stream, see, that's part of the technical, and it's not very sophisticated technology here that I'm using. It's I have to be able to run the audio and record it and get the stream. And I have two audio streams. I have me, and then I have you on the caller line. So that has to be routed through the mixer. And for some reason, it worked on Wednesday, but not so much today. But I am recording it. It's fine. It doesn't make a difference that I had to make that minor adjustment. It shouldn't matter, but then again, with this show, it does.
Needs to be a simpler system, it seems.
It is simple. That's what's so galling about this, though. It's Mac. I mean, it's very simple. Like I said, I have to route the call line from the one computer. See, I used to have the other computer over here, and it was easy. I just routed the audio and everything from there into the mixer. But I can't use that computer anymore because the jacks aren't working. It's just too old. It's like that whole, $10 hooker kind of deal. So I'm doing it like I did before with the Mac, and I would just run everything on the one computer. But like I said, there's two audio streams, and you can't because of that. If I don't use the mixer, you'll only hear the mic. You won't be able to hear the callers. So I have to route that Skype call. I go through the mixer, and then it all comes through to the show, and everybody can hear it. So it's not a very complicated thing. It's just for some reason there was a setting on Skype that said, you're not today. So.
Gotcha. So I'm calling just to give you an update. I know you messaged me on Skype. How did it go? But I just had a pretty crazy week, and I thought I'd call in. I guess I didn't make it in time on the Wednesday show. Pretty much, I went into this adjudication. This is for the parking ticket that, I was 3 minutes late, and it's like 10 cents of expired parking. And it wanted $35 if I paid in 14 days. And then I have 14 days to dispute it. And then after 14 days, it goes up to $70. If I dispute, there's a $25 adjudication fee. So I don't know, I'm up to 105 right now. And now they said, basically I went in, I gave him the motion to dismiss. He kind of was like, quite shocked that, there was he had probably never seen a motion to dismiss. He quickly glanced at it, put it to the side, and said, "I will read it at my lunch when I go for lunch." And so I didn't really get to go through the motion to dismiss. And I said all the legal arguments are in there. And he goes, "Okay, I'll look at it." He asked me to email him a digital copy, like in Word format. He goes, "Then I can do copy and pasting when I make my decision." And then I should have I made the mistake of not just hammering down and making him make a decision or a ruling on the motion to dismiss. Then I got into some other stuff on, like, how, parking tickets wrong. I'm 3 minutes late. It amounts to like 8 cents or something like that. And how is this unfair? My intention was to, it's not like I'm trying to scam parking. I should have avoided that part, but here's the thing. The guy was nice. He was cordial. He was pleasant. I thought he was a nice guy. I'd watched 2 people before me, just like, give their reasons, because even before we go to the adjudication, they say he can't look at the adjudicator can't look at explanations or reasons. They can only look at the fact of whether or not, let's just say, the meter was expired. And there was various other infractions, different types of no parking zones, etc., that people were in there for. But at the end of the day, a few days later, I sent him the digital copy. I got a letter from the city saying the adjudicator has determined that you were parked in the parking stall where the meter was expired, so you owe $105. You have like till November 26th to pay it. After that, it goes up to like $140 now. So the guy's basically a fucking psychopath, acting all nice and pleasant. I'll say I got disarmed. I walked in there, I was pretty disarmed, like, with his nice. That's where I am right now. There's nothing on the ticket about appealing it, because even when I asked him, I go, "So if you don't rule in my favor, what happens?" He goes, "I don't know. I think you got to go downtown and pay $1,500 and go to the next level." I don't have much information what to do.
I doubt it. Yeah. I would hope it's not $1,500, but wow, that would really discourage appeals for most people. Talk about wow, well, I guess I get some guilty pleasure that you probably ruined a guy's lunch with having him have to read that motion. So yes, there's always that. But you could file to reconsider it and show that there's more than just one question here. When you're going, the court has to have jurisdiction. I mean, I'm pretty certain if you were to just make an objection and say, "Objection, there's no evidence of jurisdiction," I'm sure he would not turn around and say, "Well, jurisdiction is not really a question before us." He would insist that there was jurisdiction. That's just kind of an ego thing. They always, are supposed to have jurisdiction. It's like Trump having the best people and having and having perfect phone calls. They always have jurisdiction according to them, unless maybe you filed an action against one of their own. So you could do that. I don't see any reason why I wouldn't file a motion to reconsider that and lay it out and say, "Look, you did not answer a basic foundational question here, and that is, was there evidence from the prosecution proving personal and subject matter jurisdiction?"
Jurisdiction needs to be proven. It can't be assumed. The city hasn't offered any evidence that their laws apply to me. And he did make the assertion, "Well, they do apply." I go, "Well, then I can go set up a parking meter, make people pay, and when they don't pay, put money into my meter that I've set up. I can tow their car and extort them for more money." Right. And then he tried to say something like, "Well, I think people have tried that and it doesn't end well." And he tried to say, "Oh, is this a sovereign citizen thing?" And I go, "No, I don't know what that is. Are you trying to label me?" I said, "I think the FBI classifies them as, domestic terrorists." But, so I did bring that up, but I don't think he's ever heard anybody challenge jurisdiction. Now, when I got my letter, I was expecting him a letter explaining why, like, the motion to dismiss was denied. There's nothing there. It just says he determined that I parked when the meter was expired.
Well, yeah, it's rare. I actually saw a 5-page decision from a judge in Oregon today, and I was shocked. I mean, it was a 5-page analysis of his denial, for his supporting his denial of the motion to dismiss, which is extremely rare. You just don't see that. But I think it could have gone in a different direction when he asserted that there was jurisdiction. Instead of so maybe I'll just put you on the spot here. Maybe what else could you have said besides going on that tangent that you did, saying that you could just set up your own meters? How else could you have done that may have been not necessarily that it would have changed things, but it would have made it a little more difficult for him to justify his position? What else could you have said instead of that?
I don't know. I got caught up in it when he said he'll look at it and he'll give it some weight. He goes, he will definitely, he goes, this is new to me, and I'll definitely take a look at it. I didn't know. I wasn't prepared, I guess.
But I'm talking about
what could I have said?
I'm talking about, well, specifically regarding his assertion that there was jurisdiction. How you could have done that? How you could have fielded that better than just going on and saying, well, if I was to just get my own, meters and set that up, I wouldn't it have been better to have asked him, or maybe made an objection and ask something along the lines of, when he says that there is jurisdiction, is that because you say so, or because the prosecution's evidence, says, proves that? Don't you think that would have been maybe fared a little bit better?
Oh yeah, that definitely. If I had put it in that context, it might have gone better. I think I got to listen back to the recording. I think I did say jurisdiction must be proven. Like, I did mention that 3 or 4 times, and I go, the officer, the parking officer needs to provide evidence that the laws apply, and there is nothing there. It just shows that that's my car and there's an expired meter. But before we can address that, they need to prove that the laws apply to me. Well, but I should have said, is that because you say so, or because they've provided evidence?
And a lot of what you're saying wasn't necessarily wrong, though. It's just the manner in which you're saying it that I think is wrong, and in that you're making affirmative statements, which I'll agree with you. And I think most people out of court and not in that situation would agree. Okay, jurisdiction has to be proven. It is the prosecution's burden. There is no reasonable dispute to that. It would have been better to have asked him, well, doesn't the prosecution don't they have the burden of proving jurisdiction before we can proceed? Put it to him in leading questions like that, so that he can't just, he can ignore. True. He can just ignore your statement, but he can also just disagree with you. And then what are you going to do? You're going to get an appellate panel to agree with you? No, maybe not. I think it's better to use just the questions, but doesn't the prosecution have such a burden? And you can say, well, so is it your position that jurisdiction does not have to be proven? I mean, at least something like that can be, I would think, a pretty solid appealable error for a violation of a fair hearing and due process. If you had to do that, if you were to ask those questions and use those answers against them.
So where do I stand now? I mean, I got to call the city and ask them how to appeal it, or what's the next step, because they should put that on the letter, like what my next options are, not like pay. And if you don't pay, it's going to go up even more.
Well, they'll tell you that. They've been telling you that. I would file, for now, what I would do is I would file a motion to reconsider the decision, and put in there my primary reason being that the record doesn't show sufficient facts to establish personal and subject matter jurisdiction. And I would put in there whether or not you were there when the parking meter expired is completely irrelevant in this context if they haven't established jurisdiction first. Jurisdiction is what they tell me is a threshold issue. So if they have not proven jurisdiction, which here it's clear it hasn't. And it's not like even some of these other cases where they're making assertions, like in Blake's case. Then if they haven't proven it, which they haven't, then the merits, like I said, are completely irrelevant. And that's you can just leave it really at that. Those are your only issues.
Now, what about the fact that I don't see any ruling on the motion to dismiss? Can I bring that up and said I still need his ruling or on my motion to dismiss?
Oh, he didn't formally deny it?
No, he didn't. There's nothing in the letter I got. It just says he determined you were parked there, and that's it, and you owe money. So he didn't even address my motion to dismiss.
It's worth raising. Yeah, absolutely. I'm sorry. I wrote down it was denied, so I was under the impression he formally denied it. Okay, I made a mistake there. He didn't. All right, yeah, definitely bring that. Yeah, I would definitely bring that up. That the pretrial motions, it's in the name, should have made a ruling on the pretrial motion first.
Okay. Perfect. Oh, I got to deal with that. And I'll call you on a. So yeah, it kind of sucks. The system is like we're just. I don't even have words to describe it, man. This is a hard process. It's basically they want us to just bend over and submit and give our money.
Well, they have a force continuum if you don't. But this is why when we go in, we have to stick to the basics pretty good, because you did all right. But there were things that you could have said that would have made it at least more obvious that the process was so unfair. And so we've got to remember to stick to the basics. When possible, we should always be asking leading questions, not making such affirmative statements. It doesn't matter if your affirmative statement is absolutely correct. You've given him something to be responsive to. And having him be responsive to them is giving you due process. That's the way that, so if they're not responsive, then we can at least show that that's not fair, because if they're not being responsive, depending on the context, then you're not having something disclosed to you about the process or what's being used against you. And if that's the case, you can't effectively defend yourself. So at least you have a solid due process violation that you can show. So we need to stick to the basics and not. It's very difficult, Mac. I get it. I do it all the time too, or I'll write a document and I'll have my initial thoughts in there, what I want to say to these people. But the final draft, I have to strike that stuff out, and I have to stick with just the facts, because the facts tend to speak for themselves, at least in this context. It's not a very sophisticated or very complicated thing that we're dealing with. So, but get with me off air, and I can get you a template for a motion to reconsider or that you can file.
Okay. Now, do you think it's worth taking this? Because I mean, a part of me is really emotional and angry, and I want to take it all the way. But I mean, just the time and energy and possible expense. It's
a parking.
I mean,
ticket.
I'm a principle kind of guy, right? And I don't like the principle of this whole thing.
What I would suggest is this: it doesn't cost anything extra to file the motion to reconsider. And if you have to pay it, you pay it. I mean, what you can do, it would be more cost effective for you to file a small claim for the damages. Let's say $200 plus your time. So let's say like $500 against the city's insurance or the county's insurance. Go risk management, where we start. They typically have a form you can use. So you file your small claim for damage, and then if they turn it down, then you can go at a much lower cost into small claims. To try to get the damages that way. But appealing it, yeah, you could appeal, but it's going to cost you a lot more money. And the other thing too, if you really want, as an activist, it's a principle, you can confront the city council or the county commission, and you can raise the jurisdiction issue with them.
Okay. Well, I'm not understanding. So, what do you mean by the risk management? So, like, am I filing a small claims right now, or I have to
No.
wait till I'm not guilty, or I can do that with this thing still lingering that I owe the money?
Well, what I'm saying is that if you wind up having to pay without, because you
Okay.
don't want it to escalate, then what you can do, just for throwing numbers out, let's say you pay $200. So you bring
Okay.
a claim for now there's an insurance policy that cities and counties and states have to maintain for damages that are caused by their employees. This employee has damaged you to the tune of, let's say, $500. So you file a claim for damages against that insurance policy, and they have forms for that. So you just look up risk management for whatever city it was. If they turn it down, instead of just cutting you a check for the damages, then you can, at a lower cost and appealing, you can go and you can get it reviewed, the denial reviewed in small claims court.
Okay. Yeah, the risk management claim. Take that to small claim. Okay, now I'm understanding. Awesome. Thank you, Mark. We will talk soon. I will get a hold of you to get that motion. What is it? Motion to reconsider?
That's it.
Awesome. All right. I'll listen to the rest of the show. Thank you so much.
Appreciate the call. Mac in BC. We're going to real quick. Well, I had let me cover this before we're going to get to another call. I'm glad Atik called back. It was my fault. I don't know. I didn't change any of the settings. I didn't even use this computer until today. It sat here since Wednesday. I didn't even use. I didn't change anything. But someone, and I'm sorry, I think it was Bob Townsend was asking, what's the difference between a factual allegation and a mere conclusion? Let's say a mere legal claim or a legal determination. Really fairly easy. A statement of fact is something that actually happened. It's a person, place, a thing, something, it's something that actually happened. And so a legal conclusion is when the law is applied to those facts or that person or that situation. So an easy way to look at it is that a statement of fact is that I picked up a bat, yelled, "I'm going to kill you," and then I smashed Bob in the head. That's a statement of fact. A mere conclusion is that I committed battery with a bat. So that's the distinction there. So when somebody says, again, like, "Oh, you were speeding," when a cop or a prosecutor or a judge, and they say, "Hey, you were speeding," that is not a statement of fact. That's a legal conclusion because they're taking their laws for speeding and saying that you were speeding. The statement of fact would be when the police officer says your vehicle was traveling at 65 miles an hour on an I-10. Traveling 65 miles an hour is a statement of fact. Saying that you were speeding is a legal conclusion or legal determination. Well, we can always talk more about that. If I didn't get that in detail enough, just post and we'll cover that after the calls. I still have some other things to deal with after the calls, but let's get to our calls. We don't have a tech issue now. Atik from Sacramento, welcome back to the show.
Hey, Mark, thank you for having me back. Appreciate you. Hey, so I have an arraignment on Thursday coming up, and I've been watching your stuff. Can you hear me?
I can hear you.
Oh yeah. So I mean, the judge's main thing is that he's gonna try to give me the plea, right? That's his main thing, is try to give me the plea so he can create a contract, correct?
No. What evidence is before you in this context, this situation, that would lead you to believe that there was a contract?
Well, because the cop made me sign it, and now isn't that a contract? That Travis ticket?
He made you sign a promise to appear, right?
Yeah, I promised to appear.
Yeah.
And now I'm there appearing, and he's gonna try to give me the plea. But I mean, how can you? I mean, that's his whole point, is to make me a plea and then we go to trial, right?
Well, hey, triple digits. Yeah. Thanks, guys. I'm sorry. Got to thank Brian from High Impact Films again. Yeah, we're doing. Wow. I'm sorry. Well, their object is to get their money out of your pocket in the least amount of work possible. Yeah. Okay. So I don't think that they want necessarily a plea and then you go to trial. I think we know from experience that they want you to plea and pay.
Yeah.
But they're not trying to contract with you. They're not trying to contract you. Even though it says promise to appear, they would have went through the force continuum, because you're in Sacramento or you're in California. They would have went through the force continuum if you did not do that. So the entire thing was not consensual at all. From beginning to end, it has nothing to do with your consent. You will do it. So the idea that they're contracting, even though it's a promise to appear, what you're doing is really signing, saying, now I'm going to appear so you don't hurt me. So it's not a contract in any sense. But we don't want to get caught in this trap of using really bad arguments, which is why I titled the show today, because I've heard these recently. Saying or making the claim or arguing that it's contractual is false. There's no evidence whatsoever to show that they are trying to contract with you. So let's purge that from our language.
Okay. So, I mean, he's going to say, how do you plea? And then, like you said, I would say, has the prosecuting party submitted any evidence to show jurisdiction in this matter, right? That's the first question.
No, it depends. You see, since I'm in California, if I'm in California, I would be filing the demur. So if I'm going in on Thursday, I would have already had my motion, my demur. I would already have that filed. So if the judge is asking me how I plea, I would initially say, well, there's a demur pending that needs to be ruled on. That's first and foremost. The demur comes before a plea. And I want to say this to you directly, of course, and to anybody in California listening, or any place where they have a demur, like a motion to dismiss. If you look in the Criminal Code, Section 1004, for the demur happens before the arraignment, before a plea, rather. It is before the plea. Do not let them tell you and lie to you that you have to enter a plea before they will hear the demur, because they will turn around and tell you, just like when they say jurisdiction's a trial issue, and you show up at trial and they say, well, jurisdiction's a pre-trial. Okay. They will then turn around and say, sir, this is why you should have a lawyer. If you had a lawyer, you would understand that the law says that a demur is only proper prior to a plea. And then you could sit. So don't let them lie to you. It is absolutely before a plea. So that's why we want to go into that. There's a demur pending. Does the prosecution have evidence to overcome it? That's how I would initiate that.
So a demur is a motion to dismiss, basically?
Yes. It's just they changed the name in most places about 60-some years ago. I forget exactly, but
so that's probably what happened, because I tried to file a motion to dismiss like 2 days ago in court, and they said we can't take this. You have to give this to the prosecuting party, which is district attorney. And I don't even know, so I don't understand why they didn't let me file the motion.
Well, I always have instructions that when you have the demur, it comes with 2 other documents. It comes with the Brady request, the disclosure, discovery request, and a request for judicial notice. Because in California, you have the rules are different, so you can have judicial notice of what the laws say. Different than Arizona or the feds. Anyway, you do have to give a copy of everything you file to the prosecution, but that's why there's a certificate of service that is on the last page of the demur that you have provided a copy to them. So This is why I tend to just mail it anyway. So if they get it, the best that they would have to lie straight up because there's a certificate of service there that says you've already mailed it to the prosecution. So here, yeah, we do have reports where there are times where clerks are very resistant to accepting motions in traffic cases. This time, I think, look, guys, save yourself the time, the money, and the trouble. It's easier just to mail everything out.
Just to mail it out.
That's what I do. I mean, I would rather look. Going into court makes my skin crawl. I hate those places. I can't. So that's my own personal thing about these places. I don't like to be around such dishonest people, and it really makes my skin crawl. And most, even if it's not, it's just easier and more convenient to just mail everything. I mean, it's easy enough. That's what I do. I want to go through as little. If I'm involved in this, I want as little impact on my life as possible. So mail it.
Yeah. Okay, so if I mail it into them, Monday now because the post office is closed, they probably won't get it. And then if I go to court on Thursday, say that I followed the murder, are they going to say it's not timely?
They could argue that. Yeah, they could say they could, but the rules do say any time prior to a plea. So I hear if they want if they want the prosecution to have more time to respond, I understand that. And everyone should be able to have time necessary to respond effectively. Here, we're not dealing with a murder trial. We're dealing with traffic. We're dealing with a basic code violation. It's just the testimony of a cop. The evidence that we are looking for is supposed to be in the record. So, what kind of prep do they really need to prove personal and subject matter jurisdiction beyond looking at the record, which usually consists of just a ticket and a police report, if that? So if they want more time, then I guess I would begrudgingly say, well, if the prosecution really needs more time, then you got, it sucks because you got to come back.
So if I send it on Monday, it'll get there probably Wednesday. So if the judge says that it's not so timely, then should I say I can wait? I can give more time to the prosecution?
Well, you're not waiving your right to a speedy trial or anything like that. You can, there can be a continuance of that to allow the prosecution to respond, but that's not to be held against you. And I would be, when I've come across this, I've said, look, bottom line here is the objection, sir. The bottom line is that the evidence is supposed to be in the record already, correct? Hasn't the prosecution supposedly at this point already supposed to have proven jurisdiction just to get me here to plea? Well, if that's the case, then just a quick review of the record can dispose of this demur. Either they have the evidence or not. And if they want to refile later after correcting the record, then they can do that. But for now, we don't even need input from the prosecution to resolve this. To me, it's worth a shot. Again, they're supposed to have this evidence in the record anyway, because I can guarantee you, if you did that to them and you filed against a judge or a prosecutor, they're not going to give a damn about any input from you when they dismiss it for a lack of jurisdiction because of judicial immunity. They're not going to give a damn. They're going to do it without any personal input from you.
My best situation, let's say because I actually have a demur ready to go.
Okay.
But they didn't take it. So if I mail it to the court, so when I mail it to the court, they should receive it, right? And then do they properly put it in the right place where it's supposed to go, or what happened?
Well, these lower level courts, yes, they will get the file, to the judge. When you're working in some of the higher courts, the county courts, they will use Arizona, for example. You have to send this is the county court. So, so if we're dealing with traffic, no. But if you're at the Superior Court here in Arizona, you have to file an original with the court, with the clerk of the court, and you have to file a copy to the judge's chambers. But that's easy to do because all you got to do is look up online. They'll give you the suite number. So it'll say Judge Napolitano at Suite 101. And so it's easy enough to do that. But when you're dealing with these code violations and with police courts and municipal courts or justice courts, just sending a copy to the clerk of the court's enough to get it to the judge.
Well, it is a superior court. At least they say they are. It's called Woodland Superior Court out of Woodland. So is that a superior court or no?
Well, yeah, it would be the county court. So what are you actually charged with that it's there? Speeding? Well, yeah. Well, they did years ago in California, they blended the municipal court with the superior court. So, yeah. So that's what's going on here. So you probably don't. See, usually, when you're at that level, you'll know the judge that's assigned. I mean, usually it's in the caption, so it's not a surprise.
Yeah,
but you here, this is what your judge's initials are in the caption.
Well, when I go online and I look at my case, it has his name on there, Judge Kent O'Meara or something.
Oh, okay. Well, if you want to just be safe, you can look up Judge Myers. Did you say Myers?
Kent O'Meara or something like that.
Okay, we're just going to say Kent. You can look Kent up online, and if you need to send him a copy, and just to cover yourself, you send one to the clerk of the court, and you send a copy to Kent at his suite. So I'm speaking from experience from Arizona. I know I can go online and I can find the judge's suite number. If you can't get the judge's suite number, then you're just going to have to address it to Kent at the superior court, and then maybe on the outside put your case number on it. And in this way, you're covering yourself and you're sending the judge a copy just in case.
Oh, okay. So am I a little too late, or can this still happen, all this stuff?
I don't think it's too late. And a demur can be filed prior to the plea. I think you could do it orally. I think somebody could go in and just say, I'm going to demur. I don't see that the prosecution, and just say it, and they should make a decision. The judge should, I think, going to be fair. Look at the record before him and see if there's evidence to even hold you, it would compel you to give a plea in the first place. That to me, so I'm of the opinion that if he's asserting jurisdiction over me, then there should be evidence to prove that that's true before he does it. But
so
argue that if that's a point when he says that, you like I mentioned already. Sir, either the prosecution, the record has evidence of jurisdiction, personal and subject matter already, or it doesn't. If it does, okay, demur overruled. But if it doesn't, the demur should be ruled on and sustained. See what he says.
Gotcha.
That's the best you could do is argue that, I think.
Yeah, that's a pretty solid argument. You are the king of all this stuff, Mark. Hats off to you.
I don't know about that, but I do. I think we do a pretty good job here.
No, you do. Okay, so send one to the clerk of the court and send one to Mr. Kent O'Meara. Actually, I see his name online here, Commissioner of California Superior Court, and it says that his address is Sacramento County Courthouse, 729th Street. Is that correct?
I'm going to take your word on it. You're reading it. Does it give you a suite number?
No, it doesn't give me a suite number. It just says Sacramento County Courthouse.
You got what you need.
Funny. He's in Woodland. Why would it Sacramento County? He must have been that's probably his previous address, huh?
Well, it's giving you a different address than the court that the ticket's in?
Yeah, give me a different address. It's saying Sacramento Courthouse in two different cities.
Well, again, I know it's a little complicated, more complicated than Arizona, but not as complicated as Pennsylvania. If that's the public address, that's the address I would use. They're going to use that to get it to him. So they're going to probably have a mail delivery system at the court that it'll get to him. Put the case number on the envelope. Attention, or I would put that on the outside to help make sure that it gets routed to the right spot. And just to make sure, you always send a copy to the opposing counsel, whether that's the police officer or a prosecutor.
So I should send 3 copies: one to the judge, to the clerk of the court, and to the DA, district attorney, prosecutor.
Yes, everything you file has got to go to opposing counsel. So if you know there's a prosecutor, that's easy. Send him a copy. If you don't know if there's a prosecutor, then just send a copy to the cop at the police department, and he'll make sure that if he doesn't want to prosecute that case, he'll get it to a prosecutor. And then once the prosecutor's there and they file some paperwork, either notice of appearance or they'll file a response to the demur, then you'll know who it is and have their address.
Now, if they don't respond to the demur and just continue to railroad me, which I'm assuming they're going to try to do, is that an appealable thing? Then what do you do?
Well, yes, it's definitely want to make your objection, and certainly an appealable issue because it's a pretrial. If anyone who would say, "Oh no," if you filed against them and they filed a demur saying that there wasn't jurisdiction because there was absolute immunity, if the judge didn't rule on it and went forward, what do you think they would do?
They would say, no, there's no case. Right?
They would say that's not fair. You have to rule. No, that's not fair. You have to rule on the demur. You can't just ignore it. It's there. It's a part of the process for a damn good reason. You need to rule on that. Due process requires an honest, fair disposition. And so for them not to do that, even if you look at it from a standpoint of precious judicial resources, right? That old line. Why waste everybody's time going through all these pretrial and trial procedures when the whole thing could have been disposed of if you just made a ruling on the demur? So they're supposed to do that. But
now, if I go to court, well, one last question.
Sure.
How do based on the ticket, I don't even know who the plaintiff is because it doesn't say on the ticket who the plaintiff is. Can I ask the judge in court?
Well, they're just going to tell you it's they're going to tell you it's the people of the state of California. That's what they're going to tell you.
Yeah.
That's not.
So I'm going to say.
I don't know. I think I know where you're going. I wouldn't do that. I would go right for the throat. I would file the demur based on the lack of sufficient facts to set forth a public offense because they are assuming the foundational claim of the prosecution's case, and that's not sufficient under their own code. I would stick to issues of fact like that. I wouldn't take my focus off of that.
No. The only reason I'm saying that is that if he says that's not timely, I can say, well, I didn't know who to serve because I don't know. Isn't that something to say?
I don't think you're going to go anywhere with that. It's easy enough. It's it's common knowledge you're getting hit with this ticket. It might even say on the people of the state of California, but I don't think you're going to get anywhere with that. It's too obvious that you've got a traffic ticket. It's going to be the state, and
okay. Mark, hey, thank you so much for your time today. Thank you. Thank you so much. I can't thank you enough. Thank you.
You're welcome. Hey, good luck, and let us know on Thursday. Let me know. Send me a message and let me know how it went.
So, I tried to add you on Skype, but it seemed like it didn't go through. Did I get the right Skype thing? I don't know.
I don't know what you're doing on Skype, but you can, get with me or email me after the show. But I am at Frank Rizzo 3, so you can try again after the show.
Gotcha. Thanks a lot, Mark.
You're welcome.
Take
Appreciate the call. Atik in Sacramento. Good luck on Thursday. At least it's not a trial, just an initial appearance there, and he has the demur. I don't. This whole thing about timeliness. I get it. You should have an opportunity to respond, but you know what? The prosecutor should have his butt there, and if he is present for the arraignment. It should be in the file. Even if you're just walking in the door and the assistant said, this is your docket for today, tear them up, go get those, go get them. It's supposed to be in the file. It's just it's there. And if it's so easy to prove that the laws apply because you're physically in California, how much prep time do you need? If it's so easy and so commonly understood, if it's so easy to prove it, why would you need hours and hours or even, anything beyond a few minutes to prove it? They do it every single day. It's a part of every case. The fact that this may be the first time that someone is raising, that doesn't excuse it. And again, if it's not in the file right then and there, there's no legal justification to hold you for an arraignment. Dismiss the damn ticket, and if they can correct that, then they can file it again. But hey, we're trying to inject a little bit of rationality into the process, being logical, being fair, and the legal system. Nothing. The thing with government is not about fairness. There was something I wanted to bring up, but I'll get to the calls, and maybe at the end of the show I'll bring it up. But one of my absolute favorite Twilight Zone episodes. Watched it again last night, so I've got to mention that. So, but he's been on the show before. Regular Patriot 1 from Florida.
Hey, Mark. Nice 74 degrees here. The coolest day in it's got to be 11 months.
What's the temperature?
74 degrees.
74. That's what's the humidity like though?
It's usually like 90, and the humidity is actually low. The humidity is probably 60. So coolest day in 11 months.
Well, I grew up on Long Island where humidity, not like Florida, but it was humid, and I've been out in Phoenix too long. We got about 80 degrees, but it's like 7% humidity. So, going to say we have.
I wanted to stick to the jurisdiction issue.
Shoot.
You got subject matter, territorial, and in personam. Do all of them need to be proven before the court can, before the judge can say, well, the prosecution has proven with evidence? And what would be the evidence of such things?
I believe that they do have to prove personal and subject matter, and I'm of the school that personal and territorial are really the same thing, because territorial jurisdiction is jurisdiction over persons and property within a certain territory, so it includes personal in that. Yes, the rules require, fairness dictates, due process, and all that subject matter, especially subject matter, and personal jurisdiction have to be proven. Now, subject matter jurisdiction, unlike personal jurisdiction, cannot be waived by the parties. So it doesn't matter if two people come in and say, you're going to waive personal jurisdiction. The judge has to say, that's cool, but you can't waive subject matter jurisdiction. And the plaintiff absolutely has the burden of proof on that. And so whatever the burden of proof is at trial, that's what the burden of proof is on jurisdiction. So if it's civil, subject matter jurisdiction has to be proven by a preponderance of evidence, and if it's got to be proven beyond a reasonable doubt if it is criminal.
And an example of that evidence would be what?
I don't think that there actually is evidence to prove subject matter and territory and personal jurisdiction, because it hinges on, both of them hinge, all jurisdiction hinges on whether the application of the Constitution has been proven. So the foundational claim obviously is, for example, like for me, if I'm physically in Arizona, then the laws apply. If for you, it's if you're physically in Florida, then their Constitution applies and creates jurisdiction and obligations on you. I don't think there's any actual evidence to prove that. I mean, the best that they can do is, as far as evidence to show, I shouldn't have done the finger things. The best they can show as far as evidence or facts is that you're physically in Florida. That's something that they can actually prove, that you're physically in Florida. Whether that proves the Constitution applies is a different question, and I don't think that they can prove that. So to answer the question, at least one fact that they can give to prove personal and subject matter jurisdiction is your physical location. But that's not sufficient to prove the whole, to prove.
Well, I drive commercial, so I do have a CDL.
Okay.
So if I were pulled over that didn't cause any harm, no accident or anything, I don't believe they would have a jurisdiction because there was no accident or harm caused. But for the evidence, they could require my logbook, my manifest, and my driver's license, and a statement from my employer that I was actually on the clock and working for them at that particular time of day. And that, to me, would be evidence of subject matter jurisdiction.
Well,
I think.
subject. Okay. Well,
That would be one way to prove it.
let's see if that's true. I don't think that that's true. You know, a lot of people have said, but what if I am using the streets in the course of a business? Okay. Let's assume that. Well, let's say that you are, and we'll hear we're not even assuming you're doing that. Does that prove that the Constitution applies and creates obligations on you?
No, but it would show that I did agree to perform duties and subject myself to rules and regulations.
Well, let's look at that word agree that you used. Is the driver's license, whether it's operator or commercial, the CDL, is that voluntary or is it compulsory? I mean, do you have to do it by law?
I could not do my job without it. So I would have to get it in order to do my job.
Even aside from the job, would you be able to drive a truck without a commercial driver's license, would you be able to do that freely without any risk of going to jail and being stopped and being imprisoned?
Well, I'm guessing that any truck or say taxi cab or limousine with more than 10 people, they require a commercial license to haul people or other people's stuff.
And if they would not to get the license, what could happen to them if they did so anyway?
Well, I would probably be arrested like everybody else is.
Yeah. So the point is the licenses, we'll just say licenses in general, because, all right, licenses are compulsory. You do this or you go to jail, right?
Correct.
So you really didn't agree freely. You did it to avoid going to jail, being hurt, being punished. Correct.
But, in my view, if you're doing it for someone else, a corporation, and not on my own volition, it's not just me and my truck helping my neighbors out. If I'm doing it for someone else, hauling a complete stranger's stuff, I am working for a corporation and not myself. So I think I've left my self, I guess.
So does working for a corporation, is that evidence proving the Constitution applies?
No, but it is a contract with a contract to perform for somebody else, and they can hold you to their terms and conditions of the contract.
They can hold you to that. But if it's not evidence the Constitution applies, how can the cop through the court system then hold you accountable legitimately?
Well, I suppose it would be because I contracted with the employer that contracted with the state to perform duties and obligations. Is that, I'm guessing that's how that would connect the chain of command.
So you're trying to draw a nexus with the Constitution because the corporation only exists by law.
Well, no, I don't connect it with the Constitution. But the corporation has agreed with another corporation to do things in a particular manner, and I've agreed with one of those corporations to do their things with them. So it's not that the Constitution applies at all, but the contract with the corporations apply. Now, does the state or the government have the authority on the streets? That's another question, but I don't think the Constitution has anything to do with it. I think it's just a contract with the corporations.
Well, if it doesn't have anything to do with it, then the claim by the police officer of jurisdiction and of subject matter and personal jurisdiction can't be supported. If it has nothing to do with the Constitution, because the Constitution is what is giving the jurisdiction, personal and subject matter jurisdiction. It's the Constitution. So that's the foundation. So if you can't prove that, then the rest of it can't be proven.
Well, that makes sense. So, but they would still have to prove subject matter, which can't be waived. territorial in personam, because for California, it says that the term "this state" means the United States.
It may say includes.
And that would be a territorial thing.
Yeah, but it's. I don't like using their and trying to defend against their charges based on the interpretation of their code, what it says and what it means, because the burden of proof is going to be very high for you or me, and they're always going to have conflicting legal opinions that they can use to show. Look, they can even say the guy made a decent argument, and it sounds good on his face. It really does. But the courts disagree, and the court's view of this is going to take precedent over his. And so the trial court's always going to feel duty bound to go by what the appellate court has said. The whole stare decisis thing, that they have to, that the judge can say, I disagree with this, but I am bound. I have to be consistent with the precedent. So, and you and I don't have the money or the connections to prevail on erroneous issues of law, especially here, with this, in this particular context. I think it's better to stick to, this is the prosecution's argument. These are the facts. They're not sufficient to prove that. That's the, to me, it's the simplest, most effective way.
Okay. And one last thing, some would say that by filing a motion, you're waiving in personam. But when you qualify that motion with appearing under duress and coercion, I suppose that would qualify the motion and not actually waive in personam jurisdiction.
Well, I think the accurate way of when you file something that you're waiving, let's say personal jurisdiction, would be if you enter a plea. Or in a civil context, if you file an affirmative answer instead of challenging jurisdiction. The idea that you're waiving jurisdiction because you file a motion in general just doesn't hold any water. I mean, like you're saying, your motion could be or a demur could be a challenge to jurisdiction. Now, that may grant the court limited jurisdiction just to determine the motion, because it has to be able to do something with the motion. But that doesn't mean that you're waiving personal jurisdiction. I mean, if that were true, so we can always go back to what they do. If we file against them a complaint and they file a motion to dismiss, that doesn't mean that they're waiving personal jurisdiction. Let's say a judge, it's absolute immunity. He's not waiving jurisdiction by doing that, but he is giving the judge a limited jurisdiction to hear the motion and then dispose, and then make a determination. It's just like this whole thing going on. Somebody thinks that, I'm sorry, but I forget the name, that if you get a lawyer, you are legally an imbecile and incompetent. And I had countered that with facts, but if, because if there's many people with lawyers that also testify as a witness. And if having a lawyer makes you an imbecile, you're legally not qualified now to testify as a witness. So the easiest way to avoid a subpoena would be just get a lawyer. I'm incompetent. I'm a ward of the court. I am so it didn't make any sense. So anyway, here, about with the personal jurisdiction, filing paperwork doesn't necessarily waive jurisdiction. It can, but only in the situations I just mentioned.
Okay, and you'd want, before to continue, you'd want actually the evidence submitted on the record that proves jurisdiction.
Right, like any other plaintiff would
and
have
stand
to
on that.
Well, yes. Well, you have personal and subject matter jurisdiction. Yes, absolutely. And that should be the main focus, because nothing is relevant until they can prove that, at least even at a prima facie level at the beginning, and which they can't do. But stand on that. That's the whole focus, almost the entire focus on these types of cases is always on the foundation.
What facts do you rely on that your Constitution and code apply to me? All right. Yeah. Thank you, Mark.
You're very welcome. Always good to hear from you. guess he dropped off. Yeah, I am going to get to them. Their sovereign type arguments. It's a Saturday show, so we got a little more time. But we got Roy in Virginia. Oh, we got a New Hampshire call, so hopefully we got time for that. But now we got Roy in Virginia. Roy, welcome back to the show.
Hey, Mark, how you doing?
I'm doing well.
That's good. Yeah, I emailed you about my traffic, my court. Well, I wouldn't say it was a court, but the situation with the judge, and so I guess I told you I was gonna call on the show, and I got the chance. So now basically the story is the judge, he basically picked up the burden of proof for the cop, because when I asked the judge, Judge Kenneth Mans, that if it's a code violation or a criminal charge, he says a code violation, and I asked, well, did the cop submit any factual evidence to prove that the code is applicable to me? He immediately got upset and said, "Don't ask him no questions." So he said the cop has the burden of proof. So when I asked the cop for evidence of that the code applies in jurisdiction, the cop couldn't answer it. So the judge intervened for the cop, and then I had no way to effectively defend myself, because whenever the cop can't answer a question, the judge intervened, and I can't ask the judge any question.
Well,
and when I asked the judge, go ahead.
Well, when the judge did stop him from answering, what was said? Do you remember? What did the judge actually say?
It was on the 14th. So, that he said, I can't remember specifically.
Did he say that the officer can't give legal conclusions?
No, he didn't say none of that.
Did he say he was?
The cop keep referring to the ticket.
The ticket.
He kept referring to the ticket. Yeah.
Okay.
So basically, he kept on arguing the merit of the case, and then they had like a camera where they quote unquote said that was me going across the red light, but yet there was no image of me in that. It just showed a vehicle rolling across the light. So, and that judge asked, "Was that you?" I didn't answer any questions. I remained silent.
But okay, but did he, when he wasn't allowing the police officer to answer these questions about the facts proving his claim that the laws apply because you were physically in Virginia, did he say that the cop wasn't?
It was in Pennsylvania.
Oh, Pennsylvania. I'm sorry.
Yeah.
I didn't change my thing there. When you asked that, did the judge, in his refusal to allow an answer to the question, did he say the cop wasn't qualified or he was incompetent to answer?
No, the judge did not say none of that.
Wow.
And matter of fact, I even asked the cop, did he file a valid cause of action against me? And the cop kept referring to the ticket. I was like, it's a yes or no question. Did you file a valid cause of action against me? He said, referring to the ticket. Well, the answer is yes. And I was like, how many elements on a valid cause of action? And he wouldn't answer that. So the judge intervened again. And he said, and the judge kept saying, well, the cop proved that he has jurisdiction. And I was like, well, the cop hasn't submitted any facts. He's just given a legal determination that's based off of assumptions, not facts. And I was like, I asked the judge, I was like, well, do I have a right to due process? Do I have a right to a fair hearing for a meeting? And the judge said, I was past due process. I don't even know what that means. And then when I asked him, have you received my motions? He said, the court don't accept motions.
Oh, good Lord. Another one of these guys. Well, at any time did you based on what he's saying, because it's not enough to just say that he's not answering and that he's given an opinion. When you're asking for facts, you have to move to strike the testimony. So did you do that?
No, I didn't. I didn't do that.
Okay. I think you still have a pretty good argument here, strong case for a denial of effective cross-examination. Because if he's going to say
I appealed the case.
I'm sorry?
I appealed the case. I appealed it to a common court.
Oh, okay. So you're probably going to get a trial de novo, a new trial. Okay. Hopefully you do better on your cross with the police officer. Remember, we don't have to get into did you file a valid cause of action. I used to do that, but it's a lot more effective. Things, you learn which, based on experience from having dozens and dozens or hundreds of people reporting to you what's happening. You have to have you have to make changes so to kind of preemptive, avoid certain problems like this. We don't get into did you file a valid cause of action. It is effective. So when they say, did you file a valid cause of action? They say, well, so the tickets are, so how many elements are in a valid cause of action? That's enough to show he doesn't know what he's talking about. You have to be able to utilize that effectively. So you're showing he's not actually qualified because he doesn't know what a valid cause of action is. Officer, did you file a valid complaint against me? Great. Well, do you know what elements are necessary to constitute a valid complaint? And now you're going based on his prior statements. So if they don't allow him to answer that, now you've got denial of effective cross. He wrote the ticket. He should answer questions, even legal questions regarding that ticket. But we want to really hit them right between the eyes, right out of the gate, and stick. And that's really the thing to stick on. If you can ask the question, what facts did you rely on to support your claim that the laws apply because I was physically in Pennsylvania? If they don't allow him to answer that, you've got your reversible error. Your cross is basically done at that point. That judge has you guilty already. And nothing you say in cross-examination, nothing that cop says is going to change his mind. When they pull that, the fix is in. So you get that, you get in, you get out. There's very limited circumstances, I would imagine, Roy, where that would not be the case, where you could still accomplish something by cross-examining that cop under those conditions. So unfortunately, you did have to appeal.
When I filed the appeal at the court, I told the clerk what happened. I said, well, I asked him, can I file a motion in this court? They said yes, because when I was at the other lower court, the judge said they don't accept motions at that court. And two of the clerks looked at each other, and there was some kind of peculiar look that they gave each other. And I was like, oh, they know something is up with that judge.
Damn right. Man. Let's go on record once again. Any judge or clerk that says we don't accept motions is lying to you. If you can ask him, could you actually put that down on letterhead? I want to know that that's the official policy of this court. Because I can tell you,
to do what again?
You want to get that in writing. Could you put that in writing on court letterhead? I want it in writing that this court doesn't accept motions. I want it in writing, because anyone who's able to get that in writing, I will go and with the limited scope of influence that I have, a little tiny bit, I'm pretty certain that we can come up with a few $100 for a filing fee to file against a judge in that court. And then when they try to file their motion to dismiss for lack of jurisdiction because of absolute immunity, wait a minute, I thought the policy was you don't accept motions in this court. Of course, these two clerks looked at each other because they knew full well that judge is a lying crook.
Yeah. So what does it mean when a judge said that I'm past due process?
I think that was his admission saying, sir, I am absolutely through with you. Let's just do what we got to do to get a guilty verdict and get you out of my court.
Okay.
That's what that means to me. Sir, due process isn't an issue.
Got screwed.
Yeah, you're in the process of getting shafted. Let's just get it over with. A past due process? He's saying due process is not an issue here anymore. You're not getting due process. You think?
Okay. Yeah, because I'm also in the middle of filing a complaint against the judge too.
What I would do is I would You can still do that, and I would use the facts in that as the basis of my complaint against the city or the county's risk management as a claim for damages against this guy. You have him on record saying we're past due process. That he's saying due process doesn't apply. There's no other way to interpret that. You're screwed, dude. You just let's get it over with. There's no reach around here. Just get it done.
Got it. Because the way the cop was looking, you sit there at the other side of the desk, looking at the monitor with his head down, like it's the tail was stuck between his legs.
Because he's witnessing a crime. He's witnessing a crime, and he can't do anything about it.
Okay.
Little coward. He's watching somebody commit a felony right in front of him, but because he's got a black robe on, he's too afraid to do anything about it. He could have arrested that crook right then and there for obstruction.
Well, I did my little research on the judge, trying to find out he was a former cop himself.
Oh, God. Oh, man. No. Oh, there's a shock of the century. Yeah. Okay. Former. Yeah. You know, if you can send me that information, I'd like to I'd like to mention him in my video. So I'm going to include a train wreck. Your situation is the train wreck.
His name is he's a magistrate judge. His name is Kenneth Glenn Mans. He's from Chambersburg, Pennsylvania.
Okay, well, you text me, Skype me that, or email me that information, and I'll do some research and refer to him. Maybe we can find a picture, and we can discuss that. So when I do the success stories and I do my train wrecks, I can have this former cop saying that we're past due process in open court. So, all right, well, I'm going to try to get another call, but shoot me that information, and hopefully. On the new trial, it has a better resolution.
All right. Thank you, Mark.
Really you're welcome. Appreciate the call. Roy in Virginia. And don't worry, Star, we're going to get to their sovereign arguments. I'm not covering the whole gambit here today. But it looks like we got New Hampshire. We got area code 603. You're live on the No State Project. What's your name? Where you calling from?
Hi, I was calling. I'm calling about we were emailing about the prosecutor in New Jersey that was accused me of making sovereign citizen claims.
All right, what was your name?
Mikey.
Mikey. All right, Mikey. Well, tell us what you got. I may know what you're talking about, but the audience doesn't. Okay.
Do you want me to start with the stop or just what happened with the prosecutor?
Well, tell us what happened with the prosecutor. Unless the cop beats you up, then it's probably not too relevant.
Yeah, it's all the same. The stops, it's whatever it is. Generally, in New Jersey courts, they'll give you a chance to talk it over with the prosecutor. Maybe you have evidence to show that you didn't do whatever they're accusing you of, if the law is applied. And most people just plead it down to something or whatever lower offense or a higher amount.
That's not just New Jersey. That's everywhere.
I went and asked for some basic evidence. I said, "Is this all the officer's notes that you're going to rely on?" And she got angry with me for asking that. Then I asked about what evidence of jurisdiction she planned on using, and she said, "What are you talking about?" And then she said, "Well, sovereign citizen claims." And I said, "I'm not making any claims here." And then she said, "Yes, you are. I'm calling the Attorney General. We're going to have an Attorney General representative here, the State Attorney General."
Whoa.
We're going to trial. And then she threw me out.
What? Holy crap. How old was this person?
Middle age, 40s maybe.
40s or middle age now? All right. That...
And she wouldn't give me her name either. I asked for her name, and she said, "I'm not giving that to you."
Oh, my gosh. What an escalation. So asking for evidence of jurisdiction is now, in her eyes, a sovereign citizen argument. They get smarter and smarter every year, don't they? Wow. You know, I'm going to go out on a limb here and say that was an ethical violation. They have an obligation to act professionally and ethically to especially with opposing counsel or an opposing litigant. Uh, Calling the AG, this woman's got a screw loose. Either that or she's just trying.
This is municipal court.
Yeah. That's what I mean. I know. I'm figuring that, you're dealing with a traffic case, and for her to start going off the rails saying that they're going to get the AG involved for a traffic ticket because you questioned what evidence of jurisdiction, and she got mad because you questioned whether the notes were all she was using. I guess in some alternate universe, it might, with alternative facts, your question was this all you're using could be considered a low key insult. That what are you hiding? Like, what this is it? What the hell else? Ways do we? But you don't sound like that kind of guy. I got to say, this is the first time I have ever encountered, someone's ever reported that for a traffic ticket, they're going to get the AG involved.
I mean, for $85 plus court costs. I mean, this is already costing them more than whatever they would gain from it. They just expect people to plead guilty to something and pay.
It's
just process. If we all challenged it, what would they do?
Well, if we all challenged it, of course it would collapse. You just reminded me, and I hate the fact that she may actually have been Paisan, but Mary Bolivica, and she was a mountain of a woman. And she was a prosecutor in Mesa years ago, 15, 16 years ago. And she was so grossly incompetent. I remember at one point, George Foster, actually, I've mentioned this before, he threatened her because she was objecting to everything I said. Everything I said and did, she would object. And Foster couldn't take it anymore. And he says, counsel, I'm warning you. I will hold you in contempt if you don't have a legitimate legal basis for an objection. And I'm talking, Foster hated me as much as anybody could. I was like Hitler to this guy, okay? He hated me. And he said that. I can't stand you. But I have certain, anyway. So the point of this is, some of these prosecutors are so grossly inept. I'm not saying we should assume that. No, quite the opposite. But occasionally we get a Mary Bolivica. And you got one. You got a Mary Bolivica. Someone who doesn't know their butt from a hole in the ground, that she is probably... She is in her 40s and she's still doing municipal prosecutions. What does that tell you? What does that tell you, Mikey?
Not very good.
Not good.
Not very useful.
The ones who are okay, all right, maybe the middle ground to law school, they go to the prosecutor's office because they know, I don't know my butt from a hole in the ground. I couldn't argue my way out of a paper bag, but I know I can get a good job with these contacts that I'm making. So I'm going to do my time. I'm going to make 40 grand a year. They're all going to laugh at me. But once I get the contacts, we'll see who's laughing. And that's the way it goes for the ones who are okay. But the ones who suck, their career. That's what they do. Oy vey. Okay, that's I think we can end the show here. Good night. I can't go any further higher than this. So I appreciate you calling, Mike, and relating that to us. So have you filed a motion to dismiss?
Yeah, I filed the motion to dismiss, and when you go before the judge after what they hope is making the deal with the prosecutor, if you either plead guilty or you would agree to go to trial, I mentioned briefly what happened, and he said, I can't give you her name. I'm not authorized to. The judge said that. And then I mentioned the motion to dismiss. He said, we have that here, and we can't deal with this now. And I didn't have a chance to object, really. They just process you through so quickly for that stuff. So I guess it's still open and not denied. Okay. And they want to wait till trial.
Well,
so you said file the limine.
Well, the motion in limine, motion for dismissal for prosecutorial misconduct come at least 21 days after you have filed a discovery request. So
Okay, yeah, I did that more than 21 days ago.
Then I'd fire him off. I would put in the motion to dismiss for prosecutorial misconduct that she made defamatory statements towards you and is trying to bully you on a $85 ticket by calling the Attorney General's office. That she was completely unprofessional, has an anger management problem, and should be sanctioned. In addition to having it dismissed, I would definitely put in there that she's trying to smear you as a sovereign citizen, because you and I are never going to be able to find out if there was ex parte communication. She could be communicating this to the judge. He's one of them. They're sovereigns. And now,
oh yeah, they definitely talk. I observed like the week before. I went in to observe, and at the end, the prosecutor comes in and they all hang out and they're all friends. So I you know. How do you have fair and impartial with that?
Yeah. So
or it's all in the same building too. The police station is right next to the court.
That's the way it is in Tempe, Arizona. Also, it's right there. I mean, I can see I can see why they want the police over there, but the prosecutors being in the same building, that's a little bit too. But yeah, we know that they talk, and that's why I would put in there, because she is smearing you, and while you have no direct evidence, even we have no evidence at all that she's communicating this with the judge. However, the fact that she's willing to call you that in a fit of anger and threaten to have the AG, at the very least, that's a lack of candor towards a litigant, and that's sanctionable. That's unethical. She is calling you a domestic terrorist. So it's just like I think Roy had mentioned earlier. When they call you a sovereign citizen, because that is in law enforcement, that is a domestic terrorist. I'm thinking that's pretty prejudicial to you. So yeah, I would definitely raise that. And so you can email me after the show, and I'll get you templates for that.
Yeah, I have the templates. We talked a little bit about that before.
So you already have
need to finish filling them in.
Oh, you have the template for the prosecutorial misconduct?
Yeah, I think so.
Okay.
I'll check to make sure, but I think I do.
If you don't, it's no problem. Email me. I'll get that to you. And you can probably, I would still, I would take, I think it's worth a phone call to call at the prosecutor's office, the city or county attorney, whoever is doing that, and find out who that is.
Yeah, they don't really make clear how to do, because I've looked in other towns, they sometimes do have a phone number. In the town that this is related to, they just have a court clerk number. So it's not really clear. And I know they rotate I've seen 3 prosecutors in this court. So I think they rotate the prosecutors and the judges around the local courts, because it's not worth having a full-time thing. They just move around. So it's not, I don't even know if she's going to be the one prosecuting me, because there was a previous hearing where it was a younger guy.
Okay, but but for our purposes, it doesn't matter. She is already more than likely poisoned the well. If she is spreading a rumor that you are a sovereign citizen, that's going to have a direct impact on how they treat you. I mean, obviously,
if they have 8 cops there showed up heavily armed or something, I mean, how can you have a fair trial with that?
Hey, I've had trials where they had 2 or 3 deputies standing right behind me, where the so I've been there before. I get it. I'm such a dangerous guy, right? I'm the one that can order people to prison on a whim and be held completely accountable. All right, well, so so if you need that motion template, let me know. And any other questions, don't hesitate to email and call into the show again. I'd like to know how I would like to know, for my own purposes, who that attorney is. So if you can find out, I'd definitely like to know that. So
can I make one more little bit?
Oh, of course.
Yeah, I have a friend who also recently got something, and he went to just go plea it down to something else, and it was like a $50. They claimed the license plate was obscured or something. The prosecutor said, "Oh, you're challenging this? We're we're gonna push for the maximum 10 days in jail
Oh my God.
for a $50 ticket.
Oh, come on.
He said, okay, fine, I'll plead, fine, I'll to it. So he went to the judge, and they go through all the questions. Did you do this? Were you in this town, such and such? And he said, I'm only doing this to avoid jail. I'm only doing this to avoid jail. And the judge apparently thought, you know what, let's take this to trial because this is clearly something's wrong here.
Yeah, the judge could see that. Oh, they played that game, and this guy, he's okay. He's not going to come right out and say that they bullied me. All right, got ya. What town in New Jersey is this?
I'm not sure what town his is in, and I don't want to publicize what town I'm in, but
Okay.
it's pretty much all the same in New Jersey from what I'm seeing.
Some places are better than others. You're the only one that's ever reported to me that they freaked out and wanted to get the AG involved in a traffic ticket. So let me know. If you let me know off air who it is, I will not publicize it until I have your okay. I promise that. All right. But I would like to know who it is. So if you can find out, great. Just let me know. So.
All right. I'll work on that.
All right, appreciate the call. I am totally out of time. I've pushed. I know I went a little later than I normally do. I'm glad to be able to do that, but I do have other appointments I got to get to. We covered a lot of ground, and so I have to cover this their sovereign stuff. I don't want Stahl's head to explode, so I do apologize. I can't take any more calls, but I will be live. Taking calls on Wednesday. So whoever I missed today, please call early on the Wednesday broadcast. And Strawman type things, which is the thumbnail for the big show today. And the name in all caps. I covered part of this on the show today, that they are absolutely not trying to contract with you. There's just the evidence is overwhelmingly to the contrary. There is no reasonable dispute to that because the facts speak for themselves. They have a force continuum. They are not trying to contract with you. And just because they get you signed what's called an agreement, an agreement to appear, doesn't mean that there's a contract to appear. It's not. Because why? Force continuum. End of discussion, really. I hate to say that, but it really is no reasonable counter argument to that because the facts are overwhelmingly, contrary. So the name in all caps. This one, we were talking to a nice couple today, and you have to look at what the facts are. There is nothing in the paperwork to even indicate that they're charging you. And well, they're just keeping that, they're just making that a secret. But let's say for sake of argument, that's true. You can ask them. Yeah, they can lie. How does that help your defense? How is it possibly a defense? The best you could do is, well, you're not the right guy, but there's no evidence they're charging you as a corporation. And because you're making what seems to be an affirmative defense, you have the burden of proving that they are. You have to actually prove. So consider it like if your defense is not guilty by reason of mental defect, irresistible impulse, right? You, as the one raising the argument, you have to prove that. Do you think that you could actually prove that that's how they're charging you? What are you going to use? Well, I have a definition here from Black's Law Dictionary. That settled. No, it doesn't settle a damn thing. The Black's Law Dictionary is no evidence whatsoever that that's how they're charging you here. We don't want to take that. And that's assuming it's actually true but you had no actual proof. Bad argument. Our argument should be straight to the point. And in this context, it's very simple. The prosecution doesn't have evidence to support their claim. That's easy. I can prove that. Just look at the record. I can take their own admissions. Well, I don't have to prove that, and the judge won't make me. I could be like Tiffany Castillo. I don't have to prove that. Okay, and I write it down, and there's my proof. Well, Mark, where's your evidence proving that they don't have any evidence to support their claim? They actually said it. They actually said it. If in the tax realm, I've done it 1,000 times. They said it was an assumption. They said they didn't have to. So just like with Marconi and Jones with the IRS, they actually said, we don't have evidence and we don't need evidence. That's my proof. So when you start talking about these stupid, unproven, sovereign type Freeman on land arguments, even if there's a remote chance that they're actually true, how the hell are you possibly going to prove it? And so it's just like on one of my favorite movies, A Few Good Men. It doesn't matter what I know. It only matters what I can prove. Words to live by, right? That could be on the on the banner. It doesn't matter what I know. It doesn't matter what I think. It only matters what I can prove. That is so important. And so take that with and apply it to these sovereign citizen type things. Yeah, Strawman and their stupid contract. Yeah, it's you are in a fight against people who will lie continually and say things to not only bully you, but to get you convicted. They don't care. They just want to be right. So you're looking at a cult very similar to the cult of personality with Trump, where 62% in a recent poll, and I know it was a very small, it was about 400 to 500 people, 62% of polled Trump supporters say nothing he has said or done, nothing he will say or do, nothing will stop them from supporting him. Nothing. It's that closed mind that you're dealing with in court. They don't care. Look at what was reported on the show today. We had a judge say to Roy in Pennsylvania, Judge Kenneth, well, his first name is Ken, we're past due process, or you're past due process. They don't care. If you cannot prevail when you show that there's a lack of evidence and they're actually arguing they don't need evidence, if the judge is still not going to throw it out, nothing was going to prevail. Nothing. I've actually had a judge in Scottsdale Justice Court, or City Court maybe, actually strike the police officer's testimony from the record and then still found the guy guilty, saying, I don't need the police officer's testimony or the ticket. I don't need that to know that you're guilty. Because you're guilty when you walk in. But the reason why we get dismissals is because we make it too difficult for them to maintain any presumption of fairness. And when you start making these arguments, even if we take out the fact that you're considered a domestic terrorist, it's ineffective because you're taking a burden on yourself. It's ineffective and fatally ineffective because you cannot possibly prove it. And even pray tell, if you did on one of these stupid arguments, you said, I got a court case and it backs it up. They're going to have maybe a 200-to-1 ratio of cases that say the opposite. So you're not going to prevail. So let's stop using stupid arguments in court. If we're going to make an argument, it should be effective and based on the record, based on the facts, based on logic. And that is that the prosecution has failed to meet the burden, that they have not presented the facts to support their claim. That should be it. It's proven time and time again to be extremely effective. So let's stick to that. I'm sorry that I'm out of time. I do need to go, but we covered a lot of ground here today, a lot of good calls. The fact that we've got now in New Jersey, we've got a prosecutor calling the AG. I think it's just a bluff, but man, would that be funny? Wouldn't that be great if the AG came in to help on a traffic ticket? Wow. I think a prosecutor is so incompetent, they have to call the AG to prosecute a traffic ticket. Wow. That's quite something. I'm really looking forward to seeing how that one plays out. But I appreciate everyone tuning in. We had record number today, so really thanks to all the new subs, and of course Brian's audience, and of course to Brian, appreciate that. Appreciate all the support. And if you would like to help support the show, it's markstevens.sales.com and markstevens.net. And if you are being attacked by a bureaucrat, you need some consultation, you can get that at markstevens.net. And remember, we also have scripts and a motion template available that has proven to be very, very effective. But be skeptical and check out markstevens.net. You'll see for yourself. Again, I appreciate everyone tuning in. We overcame the tech issue, and we shouldn't have any more. Should be smooth sailing from now on. But till Wednesday, salud.